Yes.
Four points which I want to make, the last of which will be very short, and my estimate is 15 to 20 minutes being faster. So, first one, I want to just return back to something which we have covered, but we've never quite dug into the regulations on, and that relates to the annual review. And I'd like you to turn in the authorities bundle to page 290, where you'll be turning to regulation 19 of the 2012 regulations.
Sorry, could you just give me the page number again?
290.
Thank you.
I'm sorry, these are the 2012 regulations.
Yes, sir.
Yeah.
That's how did I misspeak?
No, I just was confirming in my mind. Thank you.
2012. And what I want to just run through is just so you have the architecture of how the annual review works in legislation. Because the point of which is clear from 19.1 is a point which was put to me earlier, which is that the Secretary of State must, in relation to each application for a maintenance calculation, fix a date at which the non-resident parent's gross weekly income is to be reviewed with reference to HMRC figures. So there has to be this review date, it's a must. It has to happen. But then what happens on that review? And that's why I say then look now to regulation 20, where you say that regulation 22, if the non-resident parent's gross weekly income as calculated in accordance with the various provisions, the Secretary of State may make a supersession decision with effect from the review date. And I say that whilst the practice may be that these annual reviews are treated like they're once a year I look at this and I have to just rerun the calculation. You must look at it, but having looked at it, you may do whatever you want to do as a Secretary of State. And I say that is then consistent with what we see in Regulation 21.
And it only applies if the figures have changed.
And then Regulation 21, updating unearned income at the review date. I don't need to read that to you, but again, what the Secretary of State is doing is in a situation where the previous decision was a variation decision. And remind the variation decision is where you apply different rules to apply a term return in capital and so on. Then it says that 21 sub 2, the Secretary of State may request HMRC for the purposes of reviewing the non-resident's weekly gross income for ... but for information. So what I just take from that, and then it goes to some questions I was put earlier, which is there must be a review. And it goes to the seeds of destruction argument, which is because there must be this review, your order only lasts 11.5 months or what happens when you down the frame it. And I say that's analysis which stops at just 19, where what we actually have is you must review it, but when you do that, you may do X, you may do Y. And I say that fits back into my argument on this question. And I think goes to both identifying why the seeds of destruction argument, it often has been made below, and it often has succeeded, but it misses the critical point, which is it's being made after there's been an annual review and there's been a supersession decision. So by the time it gets before a judge to review the legislation, you're saying the seeds of destruction were in the original order and in the regulations. But if we carry on that analogy, the germination of that seed is what happens on 20 that made it. The fact that you must review it doesn't mean you have to do anything with it. The second point I want to make then is the point which we finished on, I touched on just before lunch, which is to what extent is it helpful and of assistance to you to construe and or to have in mind the Social Security Act when you're construing the Child Support Act. And I accept, I expect it's common ground on this road, that the Child Support Act clearly does draw upon principles which are first finalised in the Social Security Act. But I say there are crucial differences between them, not just in terms of around the fringes, but in their architecture, because one thing the Child Support Act does and the Social Security Act does not do is create this shuttle or barrier between the court and the relevant government body. And therefore, just that alone, and there's such a fundamental difference in the architecture, means that just trying to drag words across and say, well, it means this here, it must mean that there, is different because whilst they may have an original foundation, what's built on top is very different. Then I want to just break down, because the argument which Mr. Atkinson makes in his skeleton argument is to say that if we look at the Social Security Act, and let's just do that now, which you find at page 88, is the section I want to turn up, which is section 8 in the current article. What he says is that when you're looking at section 8, it's equivalent to section 11 of the Child Support Act. And as I understand his argument, and he'll develop this, and as necessary I'll come back to it, I'll give you what I understand it to be. Section 8 of the Social Security Act on page 88 says that subject to the provisions of this chapter, it shall be for the Secretary of State to decide any claim for a relevant benefit. And if we just remind ourselves of what section 11 of the Child Support Act says, which is at page 21, and that is that any application for a maintenance calculation made to the Secretary of State shall be dealt with by the Secretary of State in accordance with the provisions made under this Act. So there's not an immediate linguistic similarity between them. What my learned friend says is that the word claim in the Social Security Act is doing the same work as the word application. Sorry, let me just pull up with that way how he frames it. It's doing the same word as calculation in the Child Support Act. So he says claim and calculation are analogous. Whereas I say that's incorrect. So I say if we're going to get into this exercise, which I say is of doubtful utility in any event, the analogous words are that claim and application are the same, because that's what you do to get something. You make a claim, you make an application. And then the decision in the Social Security Act and maintenance calculation or decision are the similar analogous words, because that's what you get at the end of it. And so I say that he'll develop that later, and it's necessary I'll respond to it, but I say that just on a linguistic approach, it is incorrect. I say that it doesn't make sense to say that claim and maintenance calculation are the same features, because you're taking what the route you go through to get somewhere with what you get, and you're saying they're the same, and they're not. But let's just work with Mr. Atkinson's arguments and just see where that would leave him if he's right, because he says that claim and maintenance calculation are analogous. But then if we looked at 8, back in the Social Security Act, page 89, if we look at 8 subsection 2, and I say that if he's right, then it makes large parts of the rest of his argument unsustainable. Because he says that, if we look at 8.2, and I'll make a point, where at any time a claim for a relevant benefit is decided by the Secretary of State, the claim shall not be regarded as subsisting after that time. So if I don't accept this, but if a claim and a maintenance calculation are analogous, then that would mean that the maintenance calculation would cease to exist, because it wouldn't subsist after you've gone to the CMS and you've got on his position a decision. But what I say is that then makes it very difficult for him to argue, and if he's right also for Mr. Wilkerson to argue, what they do argue, where it is said on their behalf that what you need to understand in order to know why section 10 and regulation 3.2 do not fight is that there is one single maintenance calculation which they say remains in force but is altered by decisions. So let me just make that point, if we turn back in the core bundle to page 170 and then paragraph 56, and that's taking you into Mr. Atkinson's skeleton argument.
So moving to core bundle.
Core bundle, page 170.
Sorry, page again?
170,
1 second, sorry.
paragraph 56.
already.
Yeah.
So, what Mr. Atkinson says and Mr. Wilkinson says, because I think they're at item on this, is that what you need to understand is third line of paragraph 56. Once it is understood that a single maintenance calculation is made and remains in force, and then you can get to their construction arguments. But if he's right, so I say he's not, but if he were right, then that would mean that the maintenance calculation, if it's analogous to a claim under the Social Security Act, would cease to subsist, it would go away, it would be no more. And therefore, his own analysis of this enduring maintenance calculation, the decisions that hang below it, which are the operative part, also fails. The third point I want to make is then to deal with relatively briefly, which is I think the numbers were slightly muddled up, but it is the second or a group appeal which Mr. Wilkinson pursues, which is broadly stated is that I cannot rely, it would be an oddity, if a decision which is appealed can be a decision which causes a court order to topple. And on the face of it, I say that sounds very superficially attractive, because he would say, well, if a decision happened and the consequences which flow from that, but then that is overturned on appeal. I'm just using language just to make a point rather than being just held as language within different points of regulations. Then how can something which is wrong have these enduring legal effects? And what I say about that is that what I say happened, and again, let's use the language of first instance and appeal, it's not quite accurate, but it makes the point. What happened at first instance here was that there was a maintenance calculation at a below cap amount. And what happened on appeal is that there was a maintenance calculation at an above cap amount. And I think what my learned friends would say, because they don't want their, it's essential for their job because it's not another maintenance calculation. So they would say, at first instance there was a decision at below cap, and then on appeal there was a decision at above cap. Now the operative part of that is the question of whether there was a maintenance calculation, because I say if there was, then the order ceases to have effect, and the quantum of it doesn't matter. And so the idea that what you're doing is you're relying on something which was shown to be wrong isn't a persuasive point, because the operative part, consequential part of my construction remains throughout, which is as a maintenance calculation. And that doesn't change, that's consistent through it. And so really what it is nothing to do with the appeal. It just takes us back to the point we spent a lot of time doing, which is linguistically what does the act say and mean. And then the second point of that, which is now I've worked that out. Is it correct, applying the Bennian principles, which I think Mr. Wilkinson will talk through in more detail, and I very much doubt I'm going to disagree with him about what these principles are. Once I know what it says, if it says what I say it says, then can some element of it be strained or stretched to try to get to Parliament's intention? But I say that there's not a point in relying on a decision which was overturned on appeal, because the operative part remains consistent throughout. That never changes, that always has the same consequential effect. And then it's also, I'm not sure how hard it's being pursued anymore, but there is a ground of appeal again pursued by Mr. Wilkinson that District Judge Asplin order can be construed as meaning that it somehow works its way around Section 10 and Regulation 3.2. And what I propose to on that is to see how that's developed and responding to it. What I say are the clear impediments to it is that we know, it's crystal clear, Section 10, Regulation 3.2, the maintenance calculation causes the order to cease to have effect. So to think that you can draft an order where there is a maintenance calculation but somehow you avoid that consequence is to ignore the words of the statute. We also know, as we have looked at it, Section 8.3 says that where the Secretary of State would have jurisdiction, and they clearly have where there's been a maintenance calculation, that the court cannot make, vary, or combine a I'm very much going carefully with binding order. And section 9(4) we haven't looked at, but it's related to it if people were say a consent order, which is that there cannot be an agreement between parties to oust the jurisdiction or the role of the CMS in their affairs as to child maintenance. So I say that all that it simply there cannot be a formal drafting way. You can circumvent what the statute says. Many attempts have been made, I think the most famous of which is the Christmas order, which in short form is a child maintenance order which lasts for 364 days and then self-terminates and reviews. The relevance of that is that there is a provision that says that you can't go to the CMS for 1 calendar year after an order is made, and so if you can self-destruct and reform at day 364, then you can always say you can't go back to the CMS. It seems to me that is just an obvious attempt, a creative attempt, but an obvious attempt to just defeat the statute.
Can I ask you what you understand by revive, and what is a revival of an order?
Well, I've taken it to mean that you it is either going to the CMS, you can't self-destruct and then breathe life back into it, or you can't, because we know that it ceases to have effect,
Right.
And reviving it would be that section 10 of 3.2 of cause order to cease to have effect. It does go rather to the point you asked earlier, well, is there a difference between ceasing to have effect and revoking
Yes.
expunging and so on? I mean, we went through that. Well, I think the reviving is you can't say the maintenance calculations towards order to cease to have effect. Judge says, well, I'm not satisfied with that outcome, so I will revive the order.
Yes.
Yeah. You do then have to go back to the beginning. So if the circumstances are such that there could be a further top-up order, we know that you could go back to the beginning of the process.
But if the subsequent calculation had the effect of the top-up ceasing to have effect,
Yes.
but we then find ourselves in a situation where on a further calculation, the top-up is, the calculation comes in at the maximum assessment. What happens? Are you saying then that the court doesn't have the power there to revive? And that's what?
But not to revive the
Original
cease to
order.
effect. The court can, a fresh application could be made
Yeah.
for a top-up order.
Yeah.
Because you then would say, I've got the criteria, I've got my maintenance assessments, I've got an income above the max, and it's there.
Yeah.
And agency is an authority which is in the bundle, which says that you can do that, and then also talks about the ability for mothers to then backdate that top-up order. And there's nuances about the backdating, exactly how it works, but the thrust of it is that it can be backdated so that a mother isn't, she's left by a agreement analysis, it's not that satisfaction with the cash flow of how do I cope between now and when this is dealt with, but ultimately she gets back to the position that she would be more close to. But all of this, it's so I conclude on this, which is that as soon as we get talking about scenarios, which is this is unfair and why has that happened, you take your walk back down the chain of causation, which is it's unfair because somebody that needs child maintenance isn't getting it. Why are they not getting it? Because the order ceased to have effect. Why did the order cease to have effect? Because the Secretary of State made a maintenance calculation. Why did the Secretary of State do that? I don't know. I can't explain it. That's what the rationality is. And if you look at it through that lens and you replace the Secretary of State with somebody that acts in accordance with how you individually would exercise your discretion, or how you think the collective reasonable discretion would land, you go back down that chain of causation, except on that scenario, the Secretary of State hasn't made the maintenance calculation, and therefore the order is still continuing, and that the perceived unfairness has never happened.
Mr. Justice Mostyn looks at the question of revival of an order that might have ceased to have effect in T W, I think it is. But I was, I noted, though I haven't looked at it more carefully, that in a more recent decision of Mr. Justice Williams H and I, paragraph 17, he asks the specific question: is the proper interpretation of the Child Support Act such that the issue of the annual review falls within the definition of a maintenance assessment or calculation, so as to mean that the previous court order ceases to have effect? That's page 669 of our authorities bundle. You will be able, I'm sure, to point to where he answers that question, which I haven't been able to find at the moment.
I'm afraid I can't immediately.
Right, do you see where I'm talking about?
Yeah, found the page.
Right at the top of the page.
Yeah.
Did this, and then secondly, did the CMS issue a child maintenance assessment, and did the court order cease to have effect? I just wondered whether, and I'm afraid I haven't looked at this authority with the sort of care that I'm sure you, your colleagues and your junior have, how he answers these questions.
I can answer it immediately.
All right.
Page 681.
681, thank you.
Yeah, we haven't got the law report, we've only got the printout.
Anyway, page 681,
681, paragraph 61. I'm told.
61.
58. Start at 58.
Start of 58. But right.
Cases that the time-consuming and wasteful process is indeed required.
Well, you have there is, I take from it, wasn't argued for the go and tentative views expressed. And then you do come back to the question that if an annual, if a decision taken pursuant to regulation 20 of an annual review, decision which the Secretary of State may take, and then complete what comes next, which is the Secretary can also go out and gather more information. How can that not be a calculation and maintenance made under this Act? And that, why do I say that? Because that's what Section 54 tells us is a maintenance calculation. Now, I well understand, because what you have in below paragraph 59, for example, talk about no document emerged either in or amongst the firm as a maintenance assessment have been issued at that stage, and various deficiencies in how the annual review should play. Well, if the annual review was a must, and it must generate a decision, and that was probably in the order 11.5 months after it was made, then I can see you straining at the bit to say, well, that cannot be one, and that is a ludicrous outcome. I accept that. But properly done, a annual review, we know, to go back to regulation 1920 and so on, I suppose we'll get back up. So authority bundle, page 290. An annual review where a change is made takes us to, we know what it is a supersession decision. We know that because it's referenced, for example, in regulation 20 2. I say that the tension we always have in this is that it is very easy to postulate a scenario where you say it cannot have been Parliament's intention for an order to be toppled less than 12 months after it's made. It certainly cannot be Parliament's intention for an order to topple where arguably the pair of the orders income has gone up, but just the triggering of the annual review means that you get to make an assessment each year, just like the tax each year, it happens annually. But that misses the crucial bit. The must bit is it must be reviewed. The may bit is what comes later.
They still have to do the calculation to decide.
May do.
So they've done a maintenance calculation, they decide.
Well, I say you don't. They may well do some calculations to decide, but what they don't do, because they have the ability, section 11, not to make a maintenance calculation. This is you make it or not make it, section 8 need not do it. And in every stage of the section 8 making a decision, they're given a discretion to be able to do it. Now, I come back to it, and I think this is sort of being a bit of rubber, and you can essentially see my point and go with it, or you don't, as we said. But I say there is a difference in the Act between, to go to the point you just made, the doing the calculation and then what you do at the end of it. Because, the analogy I made before, this court and appeal court did the calculation to work out what it was judged for their word. And at the end of it, despite all the industry says nothing to do with it.
No, but they still make an order. It was dismissed or allowed.
That's how, yes, but what you don't have here is there's nothing, because if you had to do it, and there's this question of may and being able to appeal against an inaction, it will be irrelevant because there would always be a conclusion full stop if it was something you could challenge. So I say that's where the Section 8 looks at it. And let me take to two, I think the final 2 points I want to just touch upon, and then they actually come out in an annual review, and then subject to any questions, I think that would be all that I want to say. Within the regulations that we have open, I want to take two regulations which are going to be 57 and then 73. So let's start with 57, which is page 304. And the point that I want to make good by looking at these is that it is part of the legislative process that it is recognised that once you get above the capped amount, it doesn't matter by how much, in the sense that whether you're over by £1 or £1 million doesn't matter. And I say that feeds back to the fact that it is recognised that the Secretary of State shouldn't be spending huge amounts of time and resources trying to work out whether somebody's only 249,000 or 253,000, because it does not matter. The first is Regulation 57, which says, we're going to look at 57.1 and then jump down to sub F. So the circumstances described for the purposes of section 28B2C of the 1991 Act, which is part of the an application for a variation. And then it's if you come down to F, in the case of an application on any of the grounds mentioned in chapter 3, that the amount of the non-resident parent's gross income without taking that ground into account is the capped amount. And you try and just unpack that. What it's saying is that if you're asked to do a variation calculation for sex status, and it is please calculate as per the formula this payer's gross weekly income, and please take account of the fact that there's a rental income and he has £500,000 in the bank. Once you get to the point that the gross weekly income, without having to trouble yourself with the variation cost, that's the rental income or the return on capital or the diverted income or all the other features you can do, once that gets above the capped amount, then pursuant to this regulation, the Secretary stops. The Secretary doesn't need to carry on going, because the Secretary doesn't need to know whether it's 220, 550, 7.3 million. But once it's above the capped amount, it stops. And I say that feature then features in, it goes back to Secretary of State needs to do calculations, needs to get to the end of this and then tell you the conclusion, but the secretary state doesn't, because it's recognised that I need to, the secretary state decide, I will do cap now. If you get there on just income, that's even my account, just generically, because I'll get onto the options, I'll just stop, because I don't need to do any further. What does it matter? And so that then feeds into the idea that the secretary state isn't besotted by working out the details above. They want to go to 156, 100%, 158 to get comfortably past the mark, but it isn't going to be troubled by 250 versus 275. And the second place, which makes a very similar point, is Regulation 73, which is at page 305. Which is subheading effect on the maintenance calculation of additional income grounds, subject to paragraph 2 in Regulation 74. Strongly believe this. Effect is to be given to the variation by increasing the gross weekly income of the non-resident parent, which will otherwise be taken into account by the weekly amount of the additional income, except that you're doing a variation, you take account of how you increase it through the variation, except that where the amount of gross weekly income calculated this way would exceed the capped amount, the amount of the gross weekly income taken into account is to be the capped amount. Because again, formula saying, we'll get up to the capped amount, and then we can see the calculation may be obvious if it's way beyond that, it may not. So once it's above it, it doesn't matter. If it's the first time I make this calculation, I tell the court that's what I've done. The court cannot make the top order as the court sees fit. The court tells the CMS that that's what they've done. The CMS gives another annual review, or either party asks for a supersession, sits down, if it's done correctly with the information as a top-up order. There is somebody earning 350,000. I've got some figures before we can now show they're earning 345,000. Okay, I've done that. There's nothing for me to do. Top-up order continues. Different scenario, which is the other fairness is a two-way street. Go back to my law, for example, or something in that kilter, which is I'm sitting down to do this and I've got someone with an income of 50,000. No obvious reason to suspect that a variation application, if made, would lead to any different outcome. I'll make a maintenance calculation. I know full well, because I have all the information exchange that will topple the order. But what it will do is immediately create the correct liability for that payer based on his income and compare it in accordance with the CMS. If you don't do it that way, and the payer goes back to court and says, see, the Secretary of State would have jurisdiction, in fact, Section 8 now. Everyone agrees, yes, Secretary of State would have jurisdiction, therefore the court cannot make very or revise, so the court's only power is to drop it into the revoke the order. So somebody that's earning 50,000 should be paying child maintenance. And also, I suppose, if you say £5,000, it needs to be paid, 10,000, it doesn't matter, but a figure needs to be paid. You're not varying it down to that figure, it just stops, because that's the only thing the court can do, and the only thing the mother can do is go to the CMS. So this idea that you can come back to court and say to the court, well, you made this order, you now need to end it or vary it, is not something which can happen under the legislation. And it can't happen under the legislation because the legislation doesn't envisage that will happen. It envisages that somebody whose earnings fall back below the capped amount into the formula territory. The order ceases to have effect. The maintenance calculation as per the formula takes effect, and that's a liability, and it's seamless. And you could have somebody that fluctuates. There'll be some people that from 150 to 160 back to 150 and they'll fluctuate between them. Now we can all find in the nuances of that, what about this and what about that. But what I say is it's rational because it's rational because that's what the legislation says. We've looked at section 8, section 10, section 54, we've looked at how you have multiple maintenance calculations, you have the arguments on whether these are. So then we then wrestle with is it fair? Is it what wrong question. Is it what Parliament intended? We don't answer that by saying, how is this operating a decade, 2 decades after the Act was drafted? We ask, did Parliament intend for the Secretary of State to act in tandem when the Secretary of State has discretion? Clearly, that's not what Parliament intended. So all of the critiques of this are not that the statute is the statute drives us into some black hole we can never get out of. It's that the Secretary of State is not using the discretion which the Secretary of State had. And I'd say that if you start at the two extremes of the wealthy footballer and my own example, or something of that ilk, you can see how it actually works. And as with any discretion, as you start pulling the extreme back, you get to the more difficult cases and the more difficult cases and the virtually impossible cases. But the Secretary of State is as well placed as a judge to make that decision. And in fact, better and quicker.
By applying the formula.
Well, yes, by applying the formula, but knowing that if they apply the formula and then make a maintenance calculation, they'll start more. Apply the formula, income 175,000. Great. Don't need to do anything, no supersession. Apply the formula, income 75,000, but we do need to do something. And the application of the formula lets you then say, right, that's the outcome. What path do I take from it? Do I go right or do I go left? Am I binary on, binary off? And that's the discretion is quite limited in the sense of it's either yes or no. It's not mainly yes and a bit of no. But the discretion, to go back to my gatekeeper analogy, allows the Secretary of State to bring all the powers that have been given, taking it away from the court, to isolate out the limited examples of people that come to the court for their orders, you know what they are, they're all we're focused on the stop orders, and also allows the Secretary of State to bring back into the Secretary of State's fold those whose income is such that is merited, knowing full well that the Secretary of State shouldn't act rationally doing that because it has consequences. The Secretary of State is not making that decision in a blindfold or just numeric on a spreadsheet of all I know is the data collected and income. Because what matters here is there a top-up order? What will I be toppled if I do this? And is that right? And all of that. You may want to take account of lots of things, but all you actually take account of is income, and of course, percentage going to the child.
And I understand what you're saying about look at the parliamentary intention. Got that. Myself, speaking completely for myself, I don't find it helpful when you've accepted that the discretion that you say is there is not used. So I don't find it helpful then to follow that up with examples of the discretion allows this, that and the other to be done. When it's everybody's case that the discretion is never used. I get completely going back to what we were talking about this morning when you were saying you've got to go on the act. You've no choice, that's where you are. Your statutory interpretation, the fact that you think it's badly handled is not for this court. So I get that completely, but for my own part, I don't find it very helpful then for you to try and bring that back in again to say, well, of course the Secretary of State could do this, could do that, there's the safety valves, when we all know they're not used ever.
Well, I think that
And in fact, the phrase you used before the short adjournment was that he either doesn't know he's got them or chooses not to use them.
is certainly the experience that you've had both.
No. I said that my experience was, but you told me with your vast experience that's your understanding of the position.
Well, it is good that you look at any degree of research on this and you stumble across very quickly the seeds of destruction. This doesn't work, and then you get. But the criticism of that is targeted at the legislation. But there is a lever which can be pulled, which is the discretion, which if it's not being pulled, if it's not being used, then to the extent that this court has any influence on that, it can say, well, the statute itself is sound, but there does appear to be cases which are being badly handled. And you say, well, I haven't got any power over Secretary. I can't force Secretary to do things differently unless there's some sort of judicial review and it's all different situation we come to. But to diagnose where the problem is, we diagnose it as that Secretary for not using the discretion that he has. We can't fix that diagnosis by trying to by fixing something else or trying to So yes, it's not very attractive in the sense of, if you I'm trying to say, we're just standing in the shoes of the Secretary of State, so well, we know we have this power, but actually in reality it's not sort of don't use it particularly effectively. But your task is to construe the statute, points on that. Think about parliamentary intention, you have my point that it's not how it operates, what was intended. And then if the problem is that the Secretary of State, all of the examples that you'll hear, where it causes carnage, it causes breakdowns, it leaves children exposed, if those things are the pinning point criticism of the Secretary of State, then fix the Secretary of State. You probably can't do it, but it needs fixing. Or don't go and break the statute. Because then we've got two dysfunctional things. We have a Secretary of State that's not functioning properly, and we have a statute that's not doing what it says on the tin.
You might not be able to answer this question. I quite understand if you can't. But the Act came into force in April 1993. Why is this a new point today?
I don't know why it's a new point today. This has only been a point which has been in the quite a long time. I suspect it may be a new point because there's not many cases where there is the will and all the funding to get it up to the Court of Appeal. And this, to get here, this had to be leapfrogged. So I suspect it was a long time ago since the Court of Appeal last heard an appeal from a Deputy District Judge. I don't know, that's like a rough, it seems it's unlikely, but it's something which doesn't happen regularly.
Deputy District Judge is also on the coattails of a circuit judge. Because we've got two appeals.
Yes, of course it is. And all my ladies and gentlemen, I'm consistent with those are my solutions.
Thank you very much indeed, Mr. Charles. Yes, Mr. Dickinson.
Yes.
Can I just say that it's 2:45 now, and no criticism, because we've been asking Mr. Charles further questions during the course of the afternoon, so we're slightly longer than his 20 minutes. There will need to be a sort of fairly hard finish at 4:30 today. Do you think you'll take up to that point, or
I think I will.
okay? And will that leave Mr. Wilkinson enough time tomorrow?
I'm sure I will.
Yeah, thank you.
Yes, so may it please, of course, I appear on behalf of Mr. Morrell. It's important in all the statutory discussions we've had so far not to lose sight of what this appeal is actually about, and it's about arrears. Mr. Morgan contacted the CMS on the 24th of September 2021, and well, we don't know precisely what he says, but what they understood him as saying is, I am unemployed. And following that, before the CMS had even taken their decision, he reduced the amount of maintenance that he was paying very substantially down to a level that he thought was fair. Miss Morrell did not delay. She made an application to enforce that came before Deputy District Judge Gleeson, and that happened on the 1st of March 2022. By that point, the CMS had made their supersession decision, and they'd superseded the calculation onto the nil rate. Now, there's a surprising result. Even Mr. Morgan says so. If you look in his counsel skeleton argument, page 51, paragraph 17, he says he knew it was wrong, but that didn't prevent him arguing successfully before Deputy District Judge Gleeson that meant that the order had ceased to have effect, and also because Miss Morrell's attempt had also been treated as an application for a fresh top-up order. Deputy District Gleeson also said he couldn't do that because there wasn't a maximum calculation in force. So Miss Morrell and Miss Antoniou both went off to the tribunal. It took until summer 2025 to resolve, and in the middle of that period, the CMS had actually revised their decision because they found that it was a misrepresentation by Mr. Morgan that he was unemployed because he wasn't unemployed, and they revised it back to its previous level. And then the tribunal concluded that at all material times, Mr. Morgan's income should be treated as over £3,000, backdated to 24th of September 2021. So at that point, the mothers went back to court. Miss Antoniou got her application in first. She claimed £159,309. and Miss Morrell made her application for 137,765. The reason the figures are different, because the period's exactly the same, is Miss Morrell, Miss Antoniou had increased. They both had £36,000 a year to start up to
44.
but Miss Antoniou went back and got hers increased to 44,000.
Yeah.
Nobody told Miss Morrell. So she, even though their circumstances are as close as they could be, they've both got one child, they're both not working, one of them lives in South London, one of them lives in Essex, they're on a different level. And this policy of compartmentalisation applied as well in these proceedings, because Miss Antoniou's enforcement application came on first before Deputy District Judge Hecht, who allowed it. And then Miss Morrell's application came on before Her Honour Judge Hutt, who didn't allow it. And Her Honour Judge Hutt was not informed that the fact that Deputy District Judge Hecht had considered exactly the same application a few months before. And I bring that up before this court because it strikes me that this cannot be right. And maybe the court will have some observations on it. But with reference to Her Honour Judge Hutt's decision, she was referred to the decision that Deputy District Gleeson had made. That was brought very much to her attention. And what her decision was that the orders had ceased to have effect, and this phrase "for all time" has been added into it. So I say there's two cardinal problems with Her Honour Judge Hutt's decision. The first is, had these orders actually ceased to have effect, which goes into this, was a new maintenance calculation. But the second point is, and it's freestanding, and it's a point my Lord has already raised, is there is this power to revive orders. And whatever the situation is, clearly this was a situation where the order needed to be revived. There was a maintenance calculation for £3,000 in excess. It had been backdated to the date when the order arguably ceased to have effect. Surely now was the time to revive it. But instead, the position that both mothers have been put in is they've been told, and this is what the position that father wants to maintain, that they have to make fresh applications for top-up orders.
And have they done that?
Miss Antoniou has, and you'll see His Honour Judge Hess's order is backdated only to September 2025 because the power to backdate is limited. So effectively the arrears in between 2021 and September 2025 are lost, are unenforceable, even though this father should have been on a maximum maintenance calculation all along. That's the problem we have. That's what this case is really about. And if Miss Antoniou's and Miss Morrell's appeal is dismissed, she will have to make a fresh application, and she can only get it backdated for 6 months because that's what the case of agency says. That there's a limited backdating power. So that's what this case is really about. And it's important not to lose sight of that. Going to my skeleton argument. This is page 158. I set out the statutory scheme there. I'm not going to go through all of it in a painstaking fashion. The point the court was very interested in is this issue of discretion. I think it's important to bear in mind that these are welfare benefits decisions, and they're not decisions made by courts, and they're decisions that are intended to be made formulaically. If I'd known this was this important, I would have flagged up this section earlier on. But section 50A of the Child Support Act 1991 is headed Use of Computers, and it says any decision falling to be made under this or by virtue of this act by the Secretary of State may be made not only by a person authorised to exercise the Secretary of State's decision-making function, but also by a computer for whose operation such a person is responsible.
It'll say use of AI very shortly, won't it?
Well, this, yes. Maybe AI can exercise a discretion. I know it's uninterrogable about why it makes the decisions it does, but the sort of computer that they are thinking of in this statute is a much simpler one, and it is a formulaic system that is designed to be applied formulaically. And when we look at things like annual reviews, which we'll come on to more, the way it works is the CMS, and I won't refer to the Secretary of State because it's a CMS in reality. CMS have a direct computer link to HMRC, it automatically requests updated information, it generates a letter. There's not a discretionary process going on. And with regard to section 2 of the Act, which is the welfare principle, I'm referring here to Child Support Legislation 17th edition by Upper Tribunal Judge Jacobs. And he draws attention to a case
Sorry,
called
could you give me the name of that? The
book,
textbook.
Child Support the Legislation 17th edition, Edward Jacobs. He refers in the commentary to a decision called Crown and Secretary of State for Social Security ex parte Biggin, 1995 1 FLR 851, and in that decision Lord Justice Thorpe in this court said, in that case considered that welfare appears to have no influence on the quantification of liability and very little on the discretion to enforce an assessment, so that the heading words of the section seem hollow indeed.
Could you just give me that citation in 1995 1 FLR?
1995 1 FLR 851.
And that was obviously decided very shortly after the
Yes.
implementation of the Act.
Yes, when it came in. No, it's not a decision. And the judges, and the commentary goes on. Provisions like this section are inevitable in any legislation affecting children. However, the scope for the exercise of discretion is extremely limited in the Act. Where there is a discretion, it may be supplemented by specified criteria, such as in variations, although these do not displace the general duty created by this section. It may be that this section states one of the principles underlying the Act as a whole, but beyond the recitation of the principle, more seeks to serve a ritual political significance than to provide a touchstone for the practical implementation of the Act. So strong words there from Tribunal Judge Jacobs. Moving on to, I've already drawn your attention to section 8, which refers to the power to make, vary or revive, and that power to revive is very important. We'll come back to that later. So looking at my...
Sorry, let's just have a quick look at that. It's actually, that isn't what the Act says, is it? The Act expressly excludes the power to revive.
Yes. When
I didn't want to misunderstand your point, but section 8.3, no court shall exercise any power which it would otherwise have to make, vary or revive.
But once the court has the power again, under section 8.7, then the powers come back. This section shall not prevent the court from exercising power which it has to make a maintenance order in relation to the child if the child if their maintenance calculations in force, the non-resident parent's gross weekly income exceeds the figure referred to, and such circumstances.
Are you in 860?
Yes, it's
Right. Yeah.
right. I'm afraid it's necessary to go on a little historical tour due to my friend's learned friend's invocation of the Child Support Management of Payments and Arrears Regulation 2009. So if we could turn to page 266 in the authorities bundle, please. Should be section regulation 2 of the 2009 regulations my learned friend referred to. You can see there's a long list of definitions, and it refers to a 1990. Basically, there's been three. If you do well.
Oh, sorry, I'm lost. Where are we?
Page 266 in the authorities.
Got it.
Yeah. If you're dealing with welfare benefits, practitioners often refer to there being a sort of permanent revolution, and there's been three statutory schemes of the child under the Child Support Act. There was the 1993 scheme, which was the first one. Then there was the 2003 scheme, which was the second one. And then the current one is called the 2012 scheme. And you can see they've changed the name as well. So they were called the Child Support Agency. Then they called themselves CMEC for a little bit, and now they're calling themselves the Child Maintenance Service. And if you look at those definitions, it says the Child Maintenance Service system means the computer system used by the Child Maintenance Service, which administers the 2012 scheme case. And then below that, the Child Support Agency system means the computer system used by the Child Support Agency, which administers the 1993 or 2003 scheme case. When the new schemes have come along, the DWP have run the two schemes side by side before closing the old scheme cases and getting people to reapply. And there's a specific statutory power to do this. It's Section 19 and Schedule 5 of the Child Maintenance and Other Payments Act 2008. It's not in my skeleton argument because I didn't know these regulations were going to come up. It will be noted that the 2009 regulations immediately come after the 2008 Act coming into force because there was a shuffling between schemes. So in these circumstances, yes, you can have two maintenance calculations because you'd have your maintenance calculation under the old 2003 or 1993 rules, and then the CMS would have, or the CSA or whatever they were calling themselves at that point, would administratively write to you and say, we are closing your case, you will have to reply again. So the old rule, and when the old rules cases get closed, they not infrequently have a large amount of arrears in them, and those arrears don't go away. There's no limitation period for child support arrears. So the 2009 rules and regulations, which my learned friend referred to, Regulation 7, provide that if the person makes overpayments in relation to their current maintenance, that can be assessed against applied against the previous rules case, the previous maintenance calculation.
And that's the reference in Regulation 7 that we were taken to by Mr. Charles
Yes.
about current maintenance calculation and previous maintenance calculation.
Different
And you
schemes.
say that's moving from one scheme to another.
Yes. I didn't refer to this because the situation now is the 2012 scheme's been in force for 14 years, and though that problem has gone away, but it was a problem at the time. Returning to the skeleton argument, I'd say there's a structure of applications. There's a maintenance calculation is applied for under Section 4, and you'll see that it can be applied for by either the person with care or the non-resident parent.
So what page are you on? Just go on.
158.
Sorry?
158 in the core bundle. Now, Section 410 is concerned with situations where there's family court orders already in place. Now, that's not this case, but I was in Mr. Justice Peel's commission lead for board. He said you might want to deal with that situation as well because it's a different situation. But if it says Section 410 AA says that if there's a maintenance order made on or after the date prescribed for the purposes of paragraph A, which is 3rd March 2003, and it's been enforced for less than 1 year beginning on the date it was made, then you can't go apply for a maintenance calculation. And that applies if parties have agreed a consent order effectively, and we'll come back to that. And that's the one where people might try to agree a Christmas order to try and avoid this. But if you look at the wording, it says in force for them, but has been so for less than the period of 1 year beginning with the date on which it was made. It's kind of hard to see how you would do that because it doesn't work for me anyhow. Not this case. And then we come on to the mechanics. So you have a maintenance calculation is dealt with under Section 11. And if we turn to Section 11 itself, page 21 in the authorities one. We can see that that is headed maintenance calculations. So a decision under section 11 is a maintenance calculation. After that, you don't get further decisions under section 11. You get decisions either the way the calculation changes is by it being superseded under section 17 rather than by fresh section 11 decisions being made. The way the calculation ends is set out in part 1 of schedule 1, which is at page 53, paragraph 16, so 53 of the authorities bundle. And that's how it says termination of calculations. A maintenance calculation shall cease to have effect on the death of the non-resident parent of the person with care with respect to whom it was made, on there no longer being any qualifying child with respect to whom it would have effect, and C, on the non-resident parent with respect to whom it was made, ceasing to be a parent of them, which I presume would be by way of adoption or something like that. As I said,
Sorry, just to interrupt there, that's quite interesting because that helps us to understand what cease to have effect actually means. And it's quite clearly defined what cease to have effect is.
yes. Yes, changes to maintenance calculations are dealt with by section 16 and 17. Section 16 allows the Secretary of State to revise a decision, and a revision is used when the decision was wrong at the effective date it was made. And Section 17 allows the Secretary of State to supersede a decision. And a supersession is used when there's been a change in circumstances since the effective date of the previous calculation. It can be seen that statutory scheme does not operate by way of series of maintenance calculations. Instead, there's been an application for a maintenance calculation, an initial decision under section 11, and then that maintenance calculation is revised or superseded by further decisions as time goes on. A maintenance calculation ceases to have effect only in the circumstances set out in paragraph 16 of the schedule. I think both of us, myself and my learned friend, both sort of take what we want from the definition clause because we both read it in support of our case. But the definition does not say each supersession decision is a separate maintenance calculation. You don't see that anywhere. This structure of decision making is common to other social entitlements, welfare benefits, and it was introduced by the Social Security Act 1998. It was introduced to the child support system at that point. As my learned friend Mr. Wilkinson Casey uncovered, the original form of Schedule 1's the Child Support Act was very different. At that point, we had child support officers, it was a completely different system, and very complicated algebraic formulas. Now, in my learned friend Mr. Charles' skeleton argument, he says that my position is not supported by Social Security law, and he cites 2 decisions of the Court of Appeal in support. However, I would respectfully submit that those decisions fully support my position. As my learned friend has outlined, I submit that the analogous term to maintenance calculation is claim. So you make a welfare benefits claim, then you receive an award, I think is the next stage. And that's why it says the claim isn't subsisting, because it becomes an award if you get any rate of welfare benefit. And then, so you've already been taken to Section 8 of the Social Security Act 1998, which is the decision one. And then the supersession power is Section 10, and it's in very similar terms to Section 17 of the Child Support Act. When the Secretary of State supersedes a welfare benefits decision, it doesn't constitute a new claim. And that's illustrated very well by the fact of, by the case of Abbas. Now, you've got that in the authorities bundle,
Yes.
but it's not a reported case despite being a court of appeal case. I summarised the facts at page 210 in the core bundle, paragraph 23.
Do you want us to look at it, or
Well, if you look at it, and I'll take you through it. So, in Abbas,
Can you tell us where it's authorities?
3 or 4, I think?
well, I'll give you a summary of it, and then we can look at the actual provisions. Now, the claimant in Abbas was a small child who'd been awarded the care component of disability living allowance at the highest rate. Now, unlike maintenance calculations, which terminate, as we've just seen, only in quite rare circumstances, like they're no longer a qualifying child, awards of disability living allowance may be for a fixed period. And on 25th of September 1997, the claimant was awarded disability living allowance for a period ending on the 23rd of January 2001. Lord Justice Chadwick said, faced with the position that the award would expire in January 2001, a further renewal claim, so a new claim, was made on the appellant's part on the 10th of August 2000. In that context, it was for a renewal of a claim for disability living allowance from 24th of January 2001, when the existing award would come to an end. On 20th of September 2020, the Secretary of State instead decided the claimant was not entitled to disability allowance from 20th September 2020, i.e. before the disability living allowance awarded on 25th of September 1997 fixed period ended. So, and this is how complicated these things get. What Lord Justice Chadwick explained was there's 2 decisions there. There's a decision firstly a decision under Section 10 to supersede from the 25th of September 1997, from 20th of September 2020, which requires a change of circumstances. Secondly, a decision under Section 8 in respect of the renewal claim not to award benefit from 24th of January 2001. And so what this decision is really about is this concept that comes up in these both the welfare benefits appeals we look at, that you cannot make a supersession decision unless you can show there's been a change of circumstances. If we go back to what Lord Justice Rick said in Wood, the Secretary of State cannot supersede an earlier decision just because he takes a different view of existing or even new medical evidence, unless such new evidence amounts to a relevant change of circumstances. So they found in the Abbas case that the Secretary of State couldn't stop it at the award from 20th from September. It couldn't supersede because they couldn't show that there'd been a change of circumstances since the initial decision. We get the same from Wood. In Wood, Mr. Wood claims disability living allowance. This welfare benefit has a care element and a mobility element. These elements can be awarded at a different rate. On 16th of November 1992, the Secretary of State made a decision under Section 8, so an initial claim decision, awarding him the mobility element from the effective date of 1991. 8 years later, Mr. Wood informed the Secretary of State that he was of the view that he should now get the care element as well. And this was not a new claim. Nobody suggested that. It was legally an application for a supersession to add the care element to the existing claim. But on the 9th of March 2001, the Secretary of State did supersede the decision, but not as Mr. Wood hoped. Instead, he superseded it by removing the care element. And that was
the care element. I thought he was asking for
removing the mobility element. So he didn't get the care element and he lost the mobility element. And it was in that context that Lord Justice Wicks made the statement I just read out, that the Secretary of State needed to show not that he hadn't got worse, so he couldn't get the care element, but also that he got better since 1992 when it was originally awarded. He needed to be satisfied there was a change of circumstances. He couldn't treat it as a new application because the award had already been made. The next authority I wanted to take you to is the one in respect of the particular nature of appeals. If we return to my main skeleton argument at page 161, please. You see at the bottom of that page at paragraph 17, I set out section 20 of the Child Support Act. It provides that the qualifying person has the right to appeal to the First Child Tribunal against a decision under section 11, 12 or 17, whether it was originally made or revised under section 16. The decision of the Secretary of State not to make a maintenance calculation under section 11 or not to supersede a decision under section 17. My lead friend did refer to this not making a maintenance calculation. The circumstances in which that would happen is if you have to, everyone has to be present in the jurisdiction. So we'll come on to Mr. Dixon eventually, and he lived in Jersey, so he wasn't. So if Miss the other party now had applied against him, initially the decision was that he wasn't habitually resident, so he couldn't make a maintenance calculation. So that's a circumstance in which the Secretary of State would refuse to make a maintenance calculation. Another circumstance is if the share, you've got to have a non-resident parent, so if the care of the child is shared equally, then neither parent will be the non-resident parent, and the Secretary of State should refuse to make a maintenance calculation. The approach.
So that's a true share care arrangement. Week in, week out, whatever.
Yes, you shouldn't.
There's no CMS. What happens?
They shouldn't be.
So what, they then go to the court?
Yes, well, if you then there wouldn't be because section 8.3 wouldn't be satisfied because it says if the Secretary of State would make a maintenance calculation, you say they wouldn't. Similarly, if someone lives abroad, it's not satisfied, so the court's got all its powers to make a child maintenance order.
So that's what's happening.
Yes.
As there's more and more shared care.
Well, what's generally happening is there's no maintenance is paid one way or the other.
Right.
There
So
was-
they're one not sort of help the other, so
Yeah.
to speak.
It will come. Because if you have one very wealthy parent and one poor parent, it will
That's what I was
come. But there was a decision where it touched upon it, I think, a high court level decision, because that is happening more and more. Yes, the appeal jurisdiction of the tribunal is very different from the appeal jurisdiction of this court. The tribunal, they're not limited to affirming or setting aside the decision under appeal. And the appellant doesn't need to satisfy the tribunal that the Secretary of State made an error at all. It's a tribunal takes the decision again and makes its own findings of fact. And I've taken you to page 709 in the authorities bundle, please. If you could read from the beginning of paragraph 54 and then down to where the red line stops. Yes, my lord. You can see that the feature is that because to vindicate the claimant's Article 6 rights, they're entitled to a complete rehearing and the matter to be considered in fresh. They don't need to satisfy the tribunal that there was a mistake or an error of any kind. And because of the way that works, the appeal tribunal jurisdiction is to take the decision again, but they have to take it under the regulations, and their decision replaces the decision of the Secretary of State, which I think is relevant later. Yes, returning to my skeleton argument, I set out the details of how maintenance calculation actually operates. So the initial effective date is set by reference to the date on which the non-resident parent is notified of the application.
Where are you reading from now? Sorry.
Back to page 162.
Yep.
Paragraph 21.
Yep.
The non-resident parent is assessed by reference to their earned income, which means salary, pension, or self-employed sole trader income. Other forms of taxable income, such as property income or dividends, are not taken into account unless a variation is applied for. The Secretary of State will obtain a historic information figure from HMRC, and this will be the non-resident parent's earned income from the most recent self-assessment tax return that HMRC has, or PAYE information if they don't file self-assessment tax returns. And this is called historic information because it might often be a couple of years out of date. The non-resident parent can request to be assessed on the current income basis instead. In practice, this only happens when the paying parent has lost their job. There is a 25% tolerance to ask to be assessed on current income, and most people's salaries don't fluctuate by 25%. So what generally happens is the paying parent's lost their job, paying parent contacts the CMS and provides its P45, and the CMS will put them on the nil rate at that point. This is obviously possible to abuse if the paying parent gets a new job and forgets to tell the CMS. So if this happens, there's provisions that mean that when the facts of the new job come to light, the resulting supersession will be backdated to when the new job was attained. And indeed, it's a criminal offence to not tell the CMS about the change of income in those circumstances when you're on the nil rate. In the supplemental skeleton argument, I wanted to emphasise that supersessions can come about otherwise than in relation to income. And that's where I didn't want your lordships to come away thinking that all supersessions relate to income, and so it makes sense that any supersession causes a top-up order to cease to have effect. Supersessions can happen for several different other reasons, and I will focus on two that have happened in this case. The first is there will be a supersession when a new qualifying child is added, and if we turn to page 290 in the authorities manual. It's a regulation you've seen before. I don't refer to it in a different context. You can see in the regulation 19.3, it says where a maintenance calculation is in force and there is a further application in relation to the non-resident parent in respect of a new qualifying child, the review date is to be aligned so that the first review date in respect of the new application is the next review date of the calculation already in force. Maybe it's not obvious that what that means. That happened in this case because there was initially one for child A, a maintenance calculation for child A. Child B wasn't born then, and child B was born, and then this.
It's not different, wholly different proceedings or.
No, it's the same
where
maintenance
two different
calculation because
mothers.
they've got a fixation on keeping a single maintenance calculation. You don't get two separate. There is one maintenance calculation for Mr. Morgan, and then the money is divided between the two mothers. That's how it works. The only way to have two maintenance calculations is if you have both parents of a child of the non-resident parent. The person with care could be a grandmother or someone like that. It obviously doesn't happen very often. That's regulation 19.4. The second is this phenomenon of the relevant other child, and that is where the non-resident parent or the non-resident parent's partner claims child benefit. So it doesn't have to be, in this case it is, but it doesn't have to be the non-resident parent's child. If the non-resident parent is living in the same household as another child,
New partner who's got their own child.
they've
from
got
an
child
earlier
benefit,
relationship.
they get a discount, and the income is reduced by 11% for one child or 14% for two children. And the way the formula works is set out in Schedule 1 is any income over £3,000 is ignored. So the discount comes after the £3,000. So even if you're over £3,000, your calculation still goes down if you have a child in your household. So this means in this case, there was a supersession when the father told the child, the CMS, which he did in this case on March 2021, that he was back living with child C and D, his two oldest children, with the woman who he was going to marry shortly, Miss Fisher. And it also means that there will be a further supersession decision when child A, so his oldest son, who's 18, stops being a relevant other child because they're no longer eligible for child benefit. And
Do you mean child A or do you mean child C?
I think you mean child C, don't you?
no, I mean child C. Sorry,
Yeah.
because
Yeah,
I've got,
I'm
I've
afraid
got my
I-
own system of referring to them.
Read it as child
No, I did.
I mean the children of
Safe.
yes, because I was going in age. Yes.
Yeah.
The oldest child, when the oldest child stops being
A relevant other child.
of a
Yeah.
child, I'm just trying to find a passage in my supplemental skeleton argument. Yes, if we go to page 217 in the core bundle. You can see I set out there that Mr. Morgan previously contended that his two oldest children weren't living with him because he said he was not had an on and off relationship with Miss Fisher. He informed the CMS in early 2021 that they were living together, and he did receive the relevant other child discount, even though he was assessed at over £3,000. His weekly liability went down to £170.80 a week, and it's an odd number because of that 14% reduction. And there'll be a further supersession when the eldest child, child C, ceases to be eligible for child benefit. That should be, if he's doing his A-levels, finishing secondary education this year, that should be the 31st of August. That's when child benefit generally finishes. So the maximum weekly liability, where there's two qualifying children, is 170.80 is up, and so it will go up to £176.20. So there will be a supersession, and that means if my learned friend's case is allowed, the top-up order that was just made by His Honour Judge Hess on the 1st of June 2026 will cease to have effect at some point in September.
So there will be. Sorry, when in August did you say that?
31st of August.
Child D.
I think it, well, the eldest.
C.
C.
See, yeah, I didn't. I made him child A. I thought he'd earned that by being the eldest. And it also means.
Sorry, just
It also means that any non-resident child parent can procure the end of a top-up order just by moving into a household with a person who has children, because that will create a supersession. Returning to my main skeleton argument at page 163. Deal there with variations. Comment that the choice of the word variation is almost designed to create confusion among family lawyers. They were called departure directions previously, which at least was a different word. They changed it. There's a number of different grounds for variation. The Secretary of State cannot agree to a variation unless the case fits within one of those grounds. If the Secretary of State or Tribunal of Appeal agree to a variation, the variation will affect the amount of gross weekly income that's taken into account for the purposes of the calculation. There are special expenses variations, which are things like contact costs, which reduce the calculation, the amount of gross weekly income. And there's additional income variations, which increase the amount of gross weekly income. But a variation is not a freestanding thing. It only takes effect either as part of an initial decision, if before, when you apply for the first time, you say, I've got contact costs, or I know my partner's got a large amount of assets, or it can happen as part of a revision, which is what actually happened in this case, or it can take effect as part of a supersession. It's still the same decision-making structure. The relevant grounds of variation in this appeal were Regulation 69, which is unearned income, which enables the Secretary of State to take into account taxable income other than earned income, so rental income in this case. Regulation 69A, assets. This enables the Secretary of State to attribute to the non-resident parent a notional income, so it's not real, but it's treated as if you've got higher income, by applying the judgment rate to qualifying assets.
Section 8,
That's the 8%. And Regulation 71, diversion of income. This again allows a notional income to be attributed to the non-resident parent where they've got the ability to control their income and they've unreasonably reduced that income. The upper tribunal's given that a very wide interpretation because that's the primary anti-avoidance mechanism. So what the tribunal found happened in this case was that Mr. Morgan was diverting his income because he had a profitable limited company and he chose not to pay himself any dividends or salary from it, and that's quite common. But my learned friend's already taken you to this. Relevantly for these proceedings, the regulations provide that if the non-resident parent's earned income is already the capped amount of 3,000, any application for an additional income variation will be rejected on preliminary consideration. The reason I flag this up is that there's no way for Miss Morrell or Miss Antoniou to future-proof themselves against this happening, because if they'd applied before September 2021 and said, oh, but Mr. Morgan's got assets, Mr. Morgan's got companies, the CMS would have gone, well, we can't do a variation because his earned income is more than £3,000 a week. Coming on to section 8, which is the core of this appeal, and we've already looked at section 8.1. And I also share my Lord's point out that it is relevant that the power to revoke a maintenance order is maintained in the court. So that power falls to the court rather than which, if things were happening automatically by way of administrative decisions, one would expect the power to revoke would go as well, because it wouldn't be needed, as the Secretary of State would be doing the revoking. Subsection 5 to 10 sets out exceptions to the general rule preventing the court from making, varying or reviving maintenance orders. Subsection 8.6 is one that's particularly in play, but it's relevant to consider the other exceptions as they form part of the reasoning below. So section 8.5 is the consent order provision, but it's worded in quite an unusual way. So it says, the Lord Chancellor in relation to Scotland, the Lord Advocate, may by order provide that, in such circumstances as may be specified by the order, this section shall not prevent a court from exercising any power which it has to make a maintenance order in relation to a child if a written agreement, whether or not enforceable, provides for the making or securing by a non-resident parent of the child of periodical payments to or for the benefit of the child, and the maintenance order which the court makes is in all material respects in the same terms of that agreement. An order's been made, bringing it into force. So what Section 8.5 allows parents to do is to agree consent orders. In order to do so, they need to make a written maintenance agreement and submit it to the court, which can only make an order in the same terms. In V&V, Mr. Justice Wilson, as he then was, said there was a mechanism where if you wanted a consent order but you couldn't agree, you could have put in a consent order for a nominal amount and immediately apply to vary it. Because on the plain reading of the Section 8.5, you'd think it'd only be if you agreed the amount, because you see the maintenance order has to be in all material respects to the same terms as that agreement. Section 8.6 is the top-up power. That's the section directly in play. I won't read that out again because we've gone through it several times. In Dixon and Rennie, which is a case that's been referred to, Mr. Justice Holman held that Section 8.6 meant that there needed to be a determination by the Secretary of State that the non-resident parent's grossly weekly income exceeded £3,000. In doing so, Mr. Justice Holman was disapproving of an overture remark by Mr. Justice Charles that the family court can make that determination for itself. I don't put that into question. Section 8.7 allows for what are frequently called school fees orders, and it will be noted that unlike a top-up order, a school fees order does not require there to be a maintenance calculation in force. Similarly, Section 8.8 allows for a disabled child order. Again, there's no requirement for a maintenance order calculation to be enforced, but both of those sections are limited solely to the extent of the expenses attributable to the disability or incurred in connection with the educational training. So it's not an escape route from the main issue of what the main maintenance should be. Moving on to Section 10, again, you've been taken through that with my learned friend, so I won't press you with it. But in relation to the regulations, if we could look at the regulations quickly. Oh no, actually, a bit of Section 10 we haven't looked at because it was, my lord did ask, yes, if we turn to page 19 in the authorities bundle, you can see that Section 10.1 is the section we've looked at before, which says where an order is made, it shall, so far as it relates to the making or securing a period of payment, cease to have effect to such extent. Whereas an agreement of a kind shall become unenforceable. So there's a deliberate choice of different words there. And I noticed one of the problems, both of the judges, both Judge Gleeson and Judge Hudd, used the word unenforceable. And I think that's part of the problem here, is the distinction between unenforceable and ceasing to have effect.
And cease to have effect, you then link back to paragraph 16 of Schedule 1.
Yes, ceasing to have effect can be revived, whereas unenforceable maybe can't. Because this is dealing with it. Because if parties have a written maintenance agreement and one of them goes to the CMS, that maintenance agreement becomes unenforceable. They can enforce it up to the effective date, but they can't enforce it past that date. Whereas, and I don't think anyone would probably think that there's any circumstances in which it can become enforceable again, even if the maintenance calculation ends. Whereas I would say it's different with court orders. One can see that they might need to be revived if there's jurisdiction to revive them. now we go on to page 65, which is the regulation 3 of the jurisdiction regulations, maintenance arrangements regulations from 1980. And a point that carried a lot of weight with Her Honour Judge Hudd was stressed by those who represented Mr Morgan below, is there is this saving at the end of the section for orders made under regulation 3.3, that the provisions of paragraph 2 shall not apply where a maintenance order has been made under accordance with section 8.7 or 8.8 of the Act, which you'll recall is the disability or school fees provision. And that is one of the points they seize upon, but I'll set out how they're meant to be operated. As the Family Court has jurisdiction to make a school fees order or disabled child order, irrespective of whether there's a maintenance calculation in force, there needed to be a saving in Regulation 3.3 to prevent orders under 8.7 or 8.8 ceasing to have effect if an application for a maintenance calculation is made subsequently. As I set out, the reason, and this has been read out by my learned friend already, but the reason why there's no saving for top-up orders is not due to an oversight. It's because there has to be a maintenance calculation in force for a top-up order to be made. A single maintenance calculation is made and remains in force until the child ceases to be a qualified child or one of the parents dies. And there's not a new maintenance calculation made every year on the annual review. With regard to orders under 8.6, which are the consent orders, under 8.5 rather, the consent orders, in those circumstances, it's always been intended and it's understood by all practitioners that it is open after a year for the parties to go to the CMS and get a maintenance calculation. So that's why there's not a saving for those orders, because it is understood the parties should negotiate, as I believe it said in the shadow, the CMS. And that's the point that Mr Justice Marston was making in TW and TM, which we'll come back to later. My learned friend went to Regulation 5, which is the notification procedures. So Regulation 5 provides that where the Secretary of State is aware of an order of the kind prescribed in paragraph 2 is in force, he should notify the court office. So it hasn't been happening in this case. And in my submission, that supports the fact that the Secretary of State does not regard his various supersession decisions as making court orders cease, or the court would be getting a lot of correspondence. Having been through the statutory provisions, it's time to consider the authorities. The short answer is there are no direct authorities. You've already looked at H&I, that's the most recent decision. Mr Justice Williams notably invokes Mordor and says this is not the day to get into this section. Askew page, if we turn to page 179 in the court bundle.
The authorities funded.
In the court bundle, because I've set it all out in my skeleton.
Sorry, which page are you on?
Page 179. It's not a properly reported case, it's just an article found in your journal. And I've copied the judgment at the bottom of paragraph 115 at the bottom of 179. Yes, so the points I make about this is it's not clear exactly what kind of child maintenance order was made in the parties' ancillary relief proceedings, but it certainly wasn't an order under 8.6, and given the date, potentially it was just an order made prior to the Child Support Act coming into force. In that period of time, this is in the old rules 1993 scheme, if a person with care applied for income support, there was an automatic application for maintenance calculation, or maintenance assessment, as then was under section 6, irrespective of the person with care's wishes. The person with care could then ask for it to be cancelled. What's clear is at this point the Secretary of State had jurisdiction to make a calculation, and you remember the wording of it, section 8.3 is if the Secretary of State could make a maintenance calculation, the court can't make an order. So that's what the decision was, the decision in that case. The next decision I'd take you to is Dixon and Renee. I said I'd come back to that. In that case, a maintenance order was made in 2007. The court had jurisdiction to make an order on the then agreed fact that the father was habitually resident in Jersey and decided that he should pay £41,000 a year on the basis that he had assets of more than £8.5 million. In March 2014, the father replied to the Secretary of State for a maintenance calculation on the grounds that he, and I say spotted, that there was an exception to the habitual resident requirement of section 44, where a non-resident parent was employed by a UK company of a specified description. The father contended that he was employed by such a company and supplied his pay slips. The Secretary of State made a maintenance calculation based on the pay slips of £26 a week, which is a lot less than £41,000 a year. So what Mr. Justice Holman made comments about shutters and things of that matter, but what he says is, however that may be, it's clear beyond doubt that the effect of section 10.1 of the 1991 Act, read with those regulations, is that on or after the effective date, whatever date that precisely was in this case, the order of District Judge Walker, insofar as it relates to periodical payments to or for the benefit of this child, has totally ceased to have effect, subject to the outcome of the mother's current appeal to the first tier tribunal and any subsequent appeals. So Mr. Justice Holman recognised, and should have been recognised in this case, that the decision made by the Secretary of State was subject to appeal. And in Dixon, it was entirely possible that the tribunal may well decide that the Secretary of State did not have jurisdiction to calculate maintenance due to the peripheral nature of the father, or indeed variations on the grounds of assets seem quite likely given he's got £8.5 million of assets. And at that point, the order could be revived. And indeed, if one looks at the decision in Dixon more carefully, Mr. Justice Holman doesn't dismiss the mother's application, as wrongly happened in this case. Instead, it's left lying there, and Mr. Justice Holman makes a lump sum order in favour of the mother, so she can pay for representation in the first tier tribunal. So it's a very different result from the result in this case. Dealing with TW and TM minors. That's in my skeleton argument at page 211. I set out, it's important to note that this is not a top-up order case. The order under appeal was not made under section 8.6. Instead, the parties had agreed a consent order under section 8.5. Then there had been an application to vary that consent order, and the father was appealing against the Deputy District Judge's decision on that variation application. These facts are recorded in Mr. J's judgment. I've set that out. What Mr. Morgan draws attention to is this passage of paragraph 8 in the judgment where it says, it follows in May of next year of this case, it will be open to the father to apply for a calculation. And the making of that calculation, the order will cease to have effect for all time and be incapable of revival. But it's important to bear in mind that this is based later on in that paragraph, as Justice Mostyn says, it must be anticipated that any calculation made in this case after May 2016 would not be a maximum calculation, with the result that the mothers would be unable to approach the court for a top-up under 8.6. So this is a case where the parties had agreed a consent order, and it was looking like once the father was assessed by the CMS, as he would be able to in a year, he would be assessed under the maximum threshold. In that case, yes, the court would not be able to revive. Well, first of all, they wouldn't be able to revive the consent order because it wasn't a top-up order, and in order to revive a consent order, you need consent. And secondly, it wouldn't be able to make a top-up order in those terms because there wasn't the jurisdiction to make a top-up order. So it's not making the point that my learned friend seems to think it's making. But this is where this phrase cease to have effect for all time and be incapable of revival has crept into the thinking. But it's from a very different context. Those are all the authorities. And with that, all that said, we can turn now and closely analyse the facts of this case. So, first maintenance calculation in this case comes when Miss Antoniou applies. I believe it was on the 2nd of March 2016 that the maintenance calculation effective date was. On the 2nd of June 2016, Son Judge Booth makes an order in favour of Miss Antoniou for £36,000 a year. Then Mr. Morgan has child B with Miss Morrell on the 12th of February 2018. They'd separated by the date of birth, and Mr. Morgan's never had any contact with child B, his own choosing. Miss Morrell applied for child support. As I've set out, the result was not a new maintenance calculation. Instead, there was a supersession from the 17th of September 2018, and now there was a maintenance calculation for 2 qualifying children, which is actually less than, doesn't double, because you get more for the first child than you do for the second. The annual review date, though, stays the same, continues to be the 2nd of March, because that's the date on which Miss Antoniou first begun the maintenance calculation. On the 28th of May 2019, Mr. Calder Hay makes an order under section 8.6 in favour of Miss Morrell, and I think we should just look at that order quickly. It's page S201 from the supplemental bundle. Page 205. The reason I've taken the court for this order, so you can have a look at it, is so the court can establish for itself that it's in exactly the form that's order 2.1 of the standard form family orders, paragraph 81. It's an exact copy, and it makes no reference to further maintenance calculations by the CMS, and that because that's not how the drafters of the standard form orders, who included Mr. Justice Mostyn, understood the system as having worked. And if one looks at the standard form orders, one can see that the next passage underneath, which can be added or removed, is a bracket. It says in the standard form orders, paragraph 81 says, for the avoidance of doubt, where the relevant child takes a pre-tertiary education gap year, delaying the commencement of tertiary education by 1 year, the child periodical payments shall be suspended for that year and shall automatically revive when the child commences tertiary education. So there's that word again. Returning to the chronology, on 15th of September 2020, District Judge Ashworth varies Miss Antoniou's order to £44,000. Miss Morrell is not notified and continues to receive £36,000. On the 2nd of March 2021 is the annual review. The HMRC information continues to be over £3,000 a week. But then on the 22nd of March, Mr. Morgan contacts the CMS to tell them he's living with child C and D and Miss Fisher in the same household, so he's got 2 relevant other children. And then on the 24th of May 2021, the CMS supersede Miss Morrell's calculation down to £170.80 a week due to 2 relevant other children. But at this point in time, he's still under salary for his Premier League football club, so his income is way over £3,000 a week. Why is he bothering to contact the CMS with this information? We do not know if this was done with the intention of forming the CS to less of a detail that was irrelevant, if the father intended to continue honouring the top-up order, or with a view to subsequently making the technical argument. On September 24th, 2021, Mr. Morgan contacted the CMS again and told them he was unemployed. He didn't tell them about his property rental income and personally owned rental properties, or his company, the M5 Services Limited, or his assets, which Mr. Judge Hess found exceeded £5 million. If he had done, the CMS would have then treated his telephone call as an application for a variation on additional income grounds, but he didn't. Mr. Morgan then reduced his payments down from £3,155 a month, which was the 3,000 plus CPI increases, to £750 a month.
To what? 3,155 to what?
3,155 to 750. Miss Morrell made her first application to enforce on the 16th of December 2021. On the 16th of February 2021, CMS made the nil decision from 24th of September 2021. However, if one looks at the proceedings before Deputy District Judge Gleeson, one can see that counsel for the father at that point was focusing on that 24th of May 2 relevant other children decision. If one looks at page 309 in the core bundle.
In the call.
Yes. If you look at the bottom of that page, Mr. Benson, as counsel for Mr. Morgan, he says, "I'm very grateful, sir. If I might start, we say the focal point of this is 24th of May 2021. That is the first important date. Now on that date, as I've already taken you to, Mr. Morgan received a new maintenance calculation. Now that is still a maintenance at the maximum assessment, but it amounts to a new maintenance calculation for the purposes of Regulation 319, I think that's wrong, of the Child Support Maintenance Calculation Regulations. What that means is that on that date, under section 10.1 of the Child Support Act, the child maintenance portion of the consent order agreed between Mr. Morrell and Ms. Morgan automatically ceased to have effect."
And then he goes on to say, so what we say is from that date, there's no top-up child maintenance as a matter of law.
So at that point, rather than it being the nil calculation they were emphasising, they were making the original point that any supersession would
Exactly. It toppled as to use.
even though it's still assessed at maximum, it will still work. If we go to the order that Deputy District Judge Gleeson made, which is at page 296. we look at paragraph 9, the actual order is the respondent's 2022 dismissal application is granted, and consequently the applicant's 2021 enforcement application is dismissed. I don't take issue with that decision. At that point, it was open to the family court to say we're not going to make enforcement decisions while it's up in the air, what the maintenance calculation is going to be, what the decision is going to be. What I would take issue with is the recital, recital 8, where it says it's further recorded the court determined that section 13 of the 2019 consent order was not enforceable on the basis that it had ceased to have effect by virtue of the CMS calculation made on 24th May 2021. I take issue with that if it's said by my learned friend that means it ceased to have effect for all time and can never be revived. There was no appeal by Miss Morrell at that point because her focus was, as she was encouraged to indeed, to go back to the CMS. And if we look at the transcript of the judgment at page 322, we can see at paragraph 13, Deputy Judicial Gleeson says, I have to say the concerns that Miss Morrell has about Mr. Morgan's disclosure, and I'm not making findings on those concerns today, Miss Morrell. I can understand why Miss Morrell has those concerns. She will want to be sure that the CMS have the fullest information that they require in order to review the assessment. And I understand that she's asked for the assessment to be redone, and she'll want to be sure that that's carried out. As far as I'm concerned, the remaking the assessment took the matter out of my jurisdiction, and therefore the application made by Miss Morrell has to be dismissed, and I do so dismiss it. So Miss Morrell was being told to go back to the CMS there, and she didn't appeal at that point because she thought, I'll go back to the CMS and then things will be resolved. Now, whenever the CMS make a decision, it's open to both parents to ask the CMS to revise it under section 16 of the Act. And indeed, if we go back to the authorities bundle and we look at section 20, which is the appeal section at page 32, you can see what the statute says there is regulations may provide that in such cases or circumstances as may be prescribed, there is a right of appeal against the decision mentioned in subsection 1A or B, only if the Secretary of State has considered whether to revise the decision under section 16. Now, that's referred to, that's a common provision across welfare benefits jurisdictions called mandatory reconsideration. Before you can appeal to a tribunal, you have to go back to the DWP or CMS and say, can you look at the decision again, can you revise it? And that commonly builds in quite a long period of delay because it can take quite a long time to revise the decision. And I'll just set out the process here of what actually happened. So it will be recalled that since the previous decision, the 24th of May 2021 decision, CMS had been assessing the father on the basis of his historic earned income. This had been obtained directly from them from HMRC from tax year 2020, and it was £3,072,613. And that was clearly more than £3,000, so only £3,000 a week was taken into account. There was no variation application applied to the calculation because there could be no additional income variation applied where the income was already over £3,000. Father was assessed on the basis that there were two qualifying children, child A and child B. Father received no shared care discount because he did not have any overnight care of child A or child B. father received the relevant other child discount because he or his partner, Miss Fisher, received child benefit for child C and D. The total child support payable was £341.60 a week. This was divided between Miss Antoniou and Miss Morrell equally, £170.80 a week. Of course, this was of little interest to Mr. Morgan, Miss Morrell, and Miss Antoniou at that point, because as the payments that they had to make to Miss Morrell were topped up to £3,155 a month, and in practice, father paid the whole amount in one lump rather than paying £178.80 a week via the CMS and topping up the payments to £3,155 per month, as technically should have done. It didn't matter. So on the 24th of September 2021, the father contacted the CMS. The information they took from his communication was that he was unemployed. Translated into CMS language, this was converted into, please no longer assess me based on my historic income figure, please instead supersede on the basis that my current income is nil. And that is what the CMS did. It's apparent the father didn't tell them, I have rental income from the properties I own, I have a limited company that's profitable, for which I draw no income, I have assets of over £31,000, because if he had, CMS would have applied a variation. Instead, it fell to the mother to ask the CMS to apply a variation, which she did by pointing out all these things were the case, and she also pointed out that she did not accept that father was unemployed, as she, and no doubt children A and B, regularly saw him on the television doing punditry. The CMS set their financial investigations unit to investigate. It's in that context that Mr. Morgan provided the earned income form, which he's put at 335 in the bundle. That's why it's dated 6th of September 2023. Eventually, and if we go to page 342 in the core bundle. Oh no, in the supplement. Yes, if you look at the second page, 343, you can see the conclusion of the investigation. 2012 is what the CMS called their computer.
Sorry, where are you looking?
Where it says, PP is the director of, and then it's blacked out, company incorporated in 2017, nature of this business is redacted. And then below that it says, decision made to revert PP, that's paying parent, back to the HMRC income that was pulled on 2012, that's the CMS's computer, for tax year 2021 and 2022, as the evidence of analysing bank statements and support the fact that PP was still working, and ultimately on checking the information provided by HMRC, and given the fact that he is director and in the public eye, there is an awareness of his presence within football, we believe he was never unemployed. Therefore, we've established he's met through evidence himself that nil income never should have been in place.
What's the date of this?
This is the 7th of August 2023 is
yes,
the
that's it.
report.
Yeah. On a complaint made a year earlier.
Yes. Yeah. And then the appeal to the tribunal actually comes after that, because it's actually Mr. Morgan who is the appellant to the tribunal, because the CMS have put things, mandatory reconsidered things back to not superseding, leaving things in the maximum calculation, and then it's Mr. Morgan who actually appeals rather than another contrary to what we thought. So then the parties go off to the tribunal, and if we return to my skeleton argument, page 174 in the core value. Takes until paragraph 85 is set out, takes until March 2025 for there to be a hearing. It's a 3-day hearing before District Judge, the first tier tribunal, District Judge Hawker, and a financially qualified panel member or an accountant. Because that's how they sit in the first tier tribunal when they're deciding these cases. They found comprehensively against Mr. Morgan. They considered some later effective dates as well, but we're really concerned only with the first one. The 24th of September 2021, they found that he had £33,713 of unearned income, and that's the rental property income. He had £143,335 of notional income from assets based on that he had £1.7 million of qualifying assets, and that he should be treated as having a further £60,465 of notional income due to not paying himself any salary from his service company, WM5 Services. So the total income was £237,513.59. The way that the appeal tribunal works is they then remit the decision to the CMS, who then implement it, and because all they would do is ultimately not supersede the decision because the income remained at £3,000 throughout. Unsurprisingly, Miss Morrell then thinks this is the time for me to enforce the past 5 years of arrears, and she applies on the 3rd of July 2025. And so we come finally to the decision of Judge Hudd on the 8th of December 2025. The emphasis on the May decision instantly remained, and it was pressed upon Judge Hudd that the Gleeson decision was binding upon her. But if we go to Judge Hudd's reasons in the main bundle at 294, paragraph 24. Says, the learned judge said, however, I do have to bear in mind that there is a distinction between the facts at the time of this case and the case before, and this case, because at that time it was considered the father was under the maximum assessable level, and there was a nil assessment, so it's not a top-up case, and the underlying facts were different at that time. So the judge rejected the idea that she was bound by the Gleeson decision. However, the judge did conclude at paragraph 34 that the order had ceased to have effect and there was nothing. She says at paragraph 35, for all these reasons, I'm satisfied that the 2019 order did cease to have effect when there were further assessments undertaken in 2021. Unhelpfully, I have not been provided with copies of the 2021 assessments. This point has not been argued, but it's occurred to me there might be a further issue raised about whether, given his income was relatively unchanged at this time, it had the effect of resulting in a new maintenance calculation as a further maximum assessment. But I note that in any event, there was a nil assessment that took effect from September 2021, and that's a very clear recalibration of its liability. The recent 2025 decision makes it clear that now the appeals have been successful and there's been a redetermination of his income, and there's been a decision for the case to be remitted for recalculation from 2021. Seems to me that the latest possible date on which the maintenance calculation could have been undertaken, and indeed the arrears only accrue from after that time. So it seems to me there's a date where there cannot have been any argument that there was a new relevant maintenance calculation. application, and therefore the order cannot possibly have survived past that date. So, for all those reasons, I dismiss the mother's enforcement application, and I will make a declaration to that effect. It's worth pointing out that Her Honour Judge Hudd, and if we turn to page 276, we can see this, was of the view that on a fresh application it could be backdated for any period of time. Where Judge Hudd says, no, he's not been rewarded for anything. Court has yet he has been making some ongoing payments which he feels are adequate, if you feel are not adequate. So if you cannot reach agreement in respect of what the level should have been from then to date, if there are arrears and how and when he's going to pay any arrears, if you agree the figure. Otherwise, you can make an application to the court. You will need to do this fairly quickly because obviously the court will delay making applications. The court will no doubt bear in mind they're deciding what any backdating to undertake. The court normally only backdates for 12 months, but the court can look to see whether there's reasons to go back further. And the legislation permits backdating back to the date of the first maintenance calculation. That's not correct. The legislation only permits it for 6 months, and the 12 months is the enforcing arrears of more than 12 months provision. I think the judge have muddled those two together. And you've seen that in supplementary bundle, page 196, you can see that His Honour Judge Hess in Miss Antoniou's application is only backdated to September 2025. So, coming to the end, because I know I've got limited time left. The first and primary point is the system doesn't work, as Mr. Morgan contends it did, and Her Honour Judge Hudd accepted. Supersession is not a new maintenance calculation, nor is it a new claim. Per Lord Justice Ricks in Wood, it's a decision that alters an existing decision. This is apparent from the structure of the statute. The initial decision which creates a maintenance calculation are made under section 11.
Sorry, can you just, you're obviously reading from a passage and would like to follow it with...
This is my notes. Right?
Oh, it's your notes, okay. Could you just take it a tiny bit more slowly then?
So it's not a
Yes.
new maintenance.
The first point is supersession is not a new maintenance calculation, nor is it a new claim. Following Lord Justice Ricks in Wood, it's a decision that alters an existing decision. And this is apparent from the structure of the statute. The initial decision, which creates a maintenance calculation, is made under section 11, which is headed maintenance calculation. Section 17, supersessions, does not refer to maintenance calculations at all, it refers to decisions. Paragraph 16 of the Schedule 1 to the Child Support Act states when a maintenance calculation ceases to have effect, usually on there no longer being a qualified child because they're above the age where a child benefit is paid. So in my submission, it's plain on the face of the statute how the system's meant to work, and there's no need to go rummaging around in the various regulations. However, I've already dealt with the fact that the child maintenance calculations support this construction. That's why they refer to calculation decisions rather than maintenance calculations. And when the context is understood, so too did the Child Support Management of Payment and Arrears Regulations 2009, which is the way there's multiple schemes. I leave my learned friend, Mr. Wilkinson, to go more into the law concerning canons of construction tomorrow, but I would submit there is an anomalous, unworkable or impractical result on father's construction, because it doesn't take into account the fragile nature of child maintenance decisions, because they can be revised by the CMS on any ground, and they were in this case, and the parties have the right of appeal, and it's an absolute right to a rehearing before a tribunal takes the whole decision again, and their decision replaces the CMS's decision. It would clearly be an anomalous and culpably unjust result if the first glance by the CMS, which the CMS has repented of and resides in this case, and the first tier tribunals comprehensively rejected, and being frank, even the father said was wrong when he saw Cottage on the post, has the effect of automatically causing the family court order to cease to have effect. It would also mean that all supersessions would have this effect, not just those resulting to income, those relating to relevant other children, which are wide open to manipulation, and even those that increase the amount of child support, such as will happen in this case when child C ceases to be available to have a child, the child support will go up slightly, it will nonetheless be a supersession and will cause any order to cease to have effect. Construction also cuts against practice. Under Regulation 5 of the Arrangements and Jurisdiction Regulations, the CMS should be writing to the court every time they take a supersession decision. It did not do so in this case, and they have not done so in any case I've been aware of. The standard form orders take no account of this phenomenon. And secondly, and this is freestanding, so even if you conclude contrary to everything I've said and find that every supersession is a new maintenance calculation and therefore causes any Section 8.6 orders to cease to have effect, I would submit that Her Honour Judge Hart erred in respect to the power to revise an order. The Section 8.3 prohibition on making, reviving or varying an order does not apply once Section 8.6 applies, because the Section 8.6 applies that the court can make and therefore can vary or revive an order. If there's a maintenance calculation enforced, income is a maximum figure and the court is satisfied. All of those criteria were met before Her Honour Judge Hutt. They weren't met before Deputy District Judge Gleeson, because income was not met at that point. But they were met before Her Honour Judge Hutt. And the obvious thing to do in that situation where the mother's just successfully proved that it was £3,000 or above all along was to revive the order, rather than saying to the mother she had to go back to the start of the process with a fresh application for a top-up order, lose 4 years of arrears, and have to start from scratch to establish the level of maintenance and use gosh knows how much court time doing so. Ms Justice Mostyn's over to remarks, which as I've shown with reference to an 8.5 consent order case, about orders ceasing at full time have been taken out of context and treated as an improper gloss on the statute. And indeed, if you read cease to have effect in those terms, it robs the word of revive of any meaning. What is the power of reviving for? There's no good reason why the orders should not be revived, and every good reason why they should. It respects the first tier tribunal's decision, it avoids the issues with backdating, and it puts the burden squarely where it should be on the father to justify variation of the family court order, rather than on these mothers to start from scratch again. Even if you find the application for revival was not properly before Her Honour Judge Hutt, your Lordship should state whether the power to revive exists and whether Her Honour Judge Hutt erred in declaring the order was unenforceable, so that the mothers in this case can apply to revive their orders and these children do not lose the benefit of thousands of pounds of maintenance. And final case I'll draw your attention to is, which you read earlier on, is H&I, where Mr Justice Williams doesn't decide the point, but does make, I think, a salient observation to the ridiculousness of this situation with judges going around in a goldfish bowl repeatedly having to revive orders, which is where you end up. Unless, are there any questions you have?
I couldn't see in the bundle, but have there been any, if I might call it, conventional annual reviews? Was there always been something going on?
No, there was one on the 2nd of March. The annual review date is the 2nd of March.
Yes, I knew that, but what I wanted to see was just effectively like the pro forma order that the CMS send out to the parties when they conducted their annual review.
Yes, there's none in the bundle. I'm sure one could be produced.
Mm.
Yeah, that would be very helpful.
They don't say this is a supersession or this is not a supersession.
I'd just like to see how they do word it. That would be really helpful.
Could that be achieved overnight, do you think? Thank you.
And the other thing is, you told us, and I didn't catch it, what number standard form the top-up order is in.
It's order 2.1, which is financial orders, and I think I said it was paragraph 81.
That's fine, we can find it.
Thank you very much. Thank you very much indeed. Mr. Atkinson, I think in view of the time, we'll start fresh at 10:30 tomorrow Mr. Wilkinson. And I detect from everything that's been said so far that we're all confident we can complete the hearing tomorrow by lunch.
Certainly, Your Lordship, you plainly read a great deal and you've heard a lot today.
Yes.
I intend to spend the evening reducing what I say tonight. So hopefully I shouldn't be too long at all.
That's very good to hear. Thank you very much indeed. Thank you.
Court rises able.